Welcome back and thank you for joining us. This PowerPoint presentation and the accompanying narration was designed for East Texas Baptist University for use in the course Criminal Justice 1311, Fundamentals of Criminal Law. And I'm Dr. Eric Hillman. The textbook that we use in this course is entitled Criminal Law, 12th edition by Joel Samaha. The viewing of this presentation is designed to supplement the reading of the textbook and not to simply replace it. Chapter 8 is entitled Inchoate Crimes, Attempt, Conspiracy, and Solicitation. This is Chapter 8C, the third and final segment of Chapter 8. When we talk about attempt, we talk about how close does a person have to get to completing a crime before they're guilty of attempting to complete the crime. In hand with that concept is the concept of abandonment. What if they then turn around and abandon their attempt? Is that a defense? If a person intends to commit an offense, they make preparations and they actually begin their attempt, but then they voluntarily abandon the attempt. They change their mind. It could be a change of heart. It could be they've repented of their sin, who knows? But all kinds of reasons would keep them from completing the act. The federal government and half of the states accept the affirmative defense of voluntarily abandoning that attempt. So if a person stops their attempt, turns around and completely abandons it, does that mean they're no longer guilty of attempt? Seems like we have a lot of cases coming out of Wisconsin. LeBaron versus State is an issue of abandonment. Mrs. Randon took a shortcut home by walking across a railroad bridge. LeBaron, however, is nearby. He has a knife. He grabbed Mrs. Randon and took her to an old shed nearby. He unzipped his pants and he pulled up her dress. What's he going to do here? Well, it's clear that he intends to rape her. She begged him, please, please don't do it. I'm pregnant, and if you do, it'll hurt the baby. He feels her stomach and realizes, yes, she is pregnant. So he decides to let her go. Of course, as soon as she makes it across the bridge and goes home, she calls the police, and the police arrest LeBaron, and they charge him with attempted rape. Well, first of all, can they charge him with rape? No, he didn't actually rape her. Did he attempt to rape her? Well, that's the question in this whole chapter. How far does he have to go before it's actually an attempted rape? But he's convicted in the trial court of attempted rape, and he appeals to the Wisconsin Supreme Court. He argues, no, I abandon it. That yes, I had made preparations, but she said, don't do it, I'm pregnant. I said, okay, I'll let you go. So I never did attempt to rape her. The DA says, you sure did. You pulled a knife, you pulled her into the shed, you pulled up her dress, you pulled down your zipper. This is already an attempt in progress. It was only at the last minute you decided because she's pregnant. That doesn't mean you're suddenly a nice guy. You attempted to rape her, and that's what we're going to convict you of. So he's convicted. In the Wisconsin Supreme Court, he says, no, I stopped. I abandoned it. The Wisconsin Supreme Court says you had the intent to rape her, you prepared to rape her, and you actually began that attempt. You pulled the knife, you drug her to the shed. Just because you didn't make penetration doesn't mean you didn't attempt to rape her. If you had made penetration, that would have been an actual rape. This is attempted rape. And they said, yep, you began the attempt when you pulled the knife, pulled her into the shed, and pulled her dress up. Even though she was pregnant, that was an extraneous factor that intervened. That kept you from actually raping her, but it didn't keep you from attempting to rape her. That attempt had already begun. And so he was guilty of attempted rape in Wisconsin. So how does the Texas Penal Code define attempt? In section 1501, with specific intent to commit the offense. So he's got to have specific intent to actually do the offense that he's charged with attempting. And he does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense. So simply, if that LeBaron case had been in Texas, simply buying a knife or obtaining a knife to use would not be enough. Simply waiting by the railroad tracks is probably not enough, but if he does more than mere preparation that tends to affect the commission of the offense, in this case a rape, but fails to affect it, that's enough. So it looks like, under the Texas definition of attempt, LeBaron would also be guilty of attempted rape. If someone is convicted of an attempt crime in Texas, the punishment is one category lower. So if someone commits a first-degree felony, the punishment range is for a first-degree felony 5 to 99 or life. However, if they attempt to commit a first-degree felony, they're charged with not the commission but the attempt. The punishment then is one category lower, a second-degree felony. So he's looking at 2 to 20 years in prison. One category lower. How does Texas look at this concept of abandonment? It's an affirmative defense, which means he has to prove it by a preponderance of the evidence. If, because of a voluntary, he did it on his own, and complete, not partial, complete renunciation, he avoided commission of the offense. So how do we know if it's voluntary? Well, the Penal Code goes on to say you didn't voluntarily renounce or abandon your attempt if you suddenly realized there was an increased probability of detection. So if you're about to rape a woman and then you see some people walking by who would hear her scream, so you decide not to do it, well, that's not really a voluntary renunciation. The only reason you stopped is because increased probability that you would be detected or apprehended or caught. And it's also not an abandonment if you're going to, say, rob one bank and decide to rob another, or rape one woman and then change and decide to rape another. So postponing your crime to a later time or transferring your crime to another victim is not an abandonment of the crime. The bottom line is, if you're charged with attempt, it's going to be pretty tough to convince the jury that you abandon it so you're a good guy. Most of this chapter we've talked about attempt, but we also need to discuss conspiracy and solicitation. So here's a group of Middle Eastern young men who were involved in hijacking the airplanes on September 11th, 2001. They had a conspiracy. They all agreed together to hijack airplanes and crash them. So conspiracy, the definition is agreeing with one or more people to commit a crime. Conspiracy is further removed than attempt. Remember, attempt, they want you to take some acts towards the attempt. A conspiracy only requires an agreement. So what if these guys are sitting in their local mosque and decide we should hijack an airplane and crash it in the World Trade Center? If they agree to do it, is that enough? It is an agreement with one or more people to commit a crime. The other issue with conspiracy is perhaps group crime is more dangerous than individual crime. None of these men in this picture, and I believe there's 19 here, none of these could have completed everything that was done on September 11th. The crash into the World Trade Centers 1 and 2, the crash in the Pentagon, the crash into the field in Pennsylvania. None of them by themselves could have accomplished all that. But working together, they were more dangerous than working separately. And so perhaps because a group of people is more dangerous than a single person, perhaps the government wants to be able to stop that even sooner than they can stop an attempt. So for an attempt, they need more than preparation. For an attempt, you need some moving forward towards the actual crime. But with conspiracy, just an agreement in some cases is enough. So when you have a conspiracy, you need an actus reus and a mens rea. As with all crimes, you need an actus reus. There are two parts. The conspiracy actus reus. What do you have to commit to be guilty of conspiracy? First of all, an agreement to commit a crime, and that's required in all states. It doesn't have to be written. It could be oral. And even if it's unspoken, it can be proved by facts or circumstances. So you have to have an agreement everywhere in all states in order to have a conspiracy. The second part is an overt act. They're going to require some act in furtherance of that agreement. That's required by the federal government in about half the states, including Texas. So in some states, you don't even need an overt act in furtherance of agreement. Some states, simply an agreement, you're guilty of conspiracy. But in Texas and the federal government, some overt act. So if a bunch of guys are talking in the club, they're at the bar, they're drinking, they're drunk, and they say, we ought to kill the governor. Yeah, we ought to kill the governor. Y'all want to kill the governor? Okay, let's go kill the governor. And then a new song comes on the jukebox, and they start dancing with some pretty girls, and they forget about the whole thing. Well, there's no overt act, so even though they had an agreement, it's not a conspiracy in Texas. However, if they agree to kill the governor, and the next day they all go out and buy a gun, that is an overt act. So, have they attempted to kill the governor by making an agreement and buying guns? No, there's no attempt. But remember, conspiracy is considered more dangerous because multiple people are involved, and so they want to stop conspiracy sooner. Here they had an agreement, the guys in the bar, and the overt act, going and buying a gun to kill the governor, and that's enough. You can now convict them of conspiracy to kill the governor, even if they made no attempt. Case out of California, Mr. Garcia is a member of the Bloods gang. Their color is red. They went to a party in Crips territory. Crips color is blue. Garcia and other Bloods started, quote unquote, talking smack, was the testimony, to Crips. So these gangs hate each other. They're always fighting. And because they started talking smack, there was a shootout between the Bloods and the Crips. 4 people were shot. And Mr. Garcia is charged with conspiracy. He didn't shoot anyone, so he can't be charged with murder, and he didn't even attempt to shoot anyone, so he can't be charged with attempted murder. But the government is trying to convict him of conspiracy to assault with dangerous weapons. Now, they have no direct evidence of conspiracy. They can't show an agreement. They can't prove that these Bloods said, let's go to Crips territory and shoot some Crips tonight. So instead, when the government alleges a conspiracy, they're saying there's an agreement. But even though it's not written or oral, the government is saying there's an implicit agreement. If a gang member gets into a fight, you have to back him up. You have to fight alongside him. So that is the agreement among gang members to become involved in fights. And this concerted or working together provocative and violent acts. So can we prove, based on mere gang membership, that someone has an agreement to commit a violent act? Here, the California Court of Appeals says inference of an agreement is permissible only when events logically require coordination and planning. So, if you have an explicit agreement where you can prove, hey, yeah, they had an agreement, let's 4 of us get together and kill some Crips tonight, shoot some Crips tonight. That's not what they had. They are inferring agreement. So basically they're saying because of circumstances, there's an implicit or inferred agreement that if one Crip gets into a fight, one Blood gets into a fight, his fellow gang members will back him up. Talking smack by itself does not prove you planned a shooting or agreed to a shooting. Gang membership by itself doesn't establish a conspiracy. If you carry a gun, yes, that shows you're ready to fight, but it doesn't show that you planned or agreed to fight. Some of these folks carry guns all the time just in case. So the court here is saying, federal government, if you want to prove a conspiracy, you've got to have more than just talking smack, being a gang member, and carrying a gun. You've got to actually prove some kind of an agreement. Can you be guilty by gang membership alone? No, you can't. And the court overturned Mr. Garcia's conviction because the government did not have any evidence of an actual agreement. And for a conspiracy, you need an agreement. Well, we know mens rea for every inchoate or incomplete crime requires intent. So just like attempted crimes require intent, so conspiracy also requires intent to commit the crime. Now, all conspirators don't have to intend to commit the crime. So if one conspirator secretly does not intend to commit the crime, the other conspirator is still a priority. So if you have an undercover officer there and there's 5 gang members and one of them's an undercover officer and all 5 agree that we're going to rob the bank or rob the 7-Eleven, just because one of them secretly has no intent at all or agreement to do it doesn't mean the others don't. So you have to have intent to commit the crime, but you don't have to prove that each member had the intent as long as some members did. Just because your undercover officer had no intent to rob the 7-Eleven doesn't mean your conspiracy theory falls apart. Now, when you have large conspiracies, there's different ways you can look at them. One is the wheel conspiracy, where one or more defendants participate in every transaction at the hub, and the other one's in only part. So this might be organized crime, where you have the leader of the cartel at the hub, at the center of the wheel, and he's participating in everything, but he's got his dealers out selling drugs in different neighborhoods. That's the wheel conspiracy. Then there's a chain conspiracy, where every participant handles the commodity at different points. So you might have the first person planting the coca plants, the second person weeding and watering the coca plants, the third person harvesting the coca plants, the fourth person transporting them to the refining center, the fifth person drying them and refining them, the sixth person processing them, cooking the leaves, so to speak, the seventh person drying in the powder, eighth person packaging the powder, the ninth person transporting the packages of powder to the border, the 10th person loading them into a boat, the 11th person transporting them to the Florida Everglades, the 12th person picking them up in the Everglades and transporting them into Georgia and Alabama, etc. So that would be a chain conspiracy. The problems with conspiracy is that because conspiracy seeks to stop a crime a long time before even an attempt happens, conspiracy can actually punish thoughts and only very small preparations. So what if these 3 or 4 guys are drinking in the club and they say we ought to kill the governor because they're drunk and they're tired of the governor's lockdown order, but they're drunk, and the next day one of them goes out and buys a gun. What if he's already forgotten what he said when he's drunk? He's just buying a gun to go deer hunting. Well, in the bar that night there was an undercover federal agent or state agent, and he heard the conspiracy, so he reports it, they investigate, and they find, yeah, these 5 drunk guys agreed together to kill the governor. And the next day, one of them actually went and bought a gun. Well, maybe when he bought that gun, he can't remember what he said when he was drunk the night before. Now he just wants to go deer hunting. Well, now he can be convicted of conspiracy to assassinate the governor. So thoughts plus very small preparations can sometimes be punished. And what we find is prosecutors attempt to prosecute people for crimes, but if they don't have enough evidence to prove the crime, then they file a charge of conspiracy, because conspiracy is so much easier to prove. The other problem with conspiracy is it can be used to punish agreement for political dissent. Normally, political dissent is protected by the First Amendment, but you get some people talking smack or getting drunk or saying little things. It doesn't take much to prove a conspiracy. What we find then is the federal government uses conspiracy law and actually abuses it, because there's lots and lots of cases the federal government can't prove the case, so instead they charge the conspiracy. Other problems with conspiracy law is RICO, the Racketeer Influenced and Corrupt Organizations Act, was designed to stop organized crime. That's good. We do need to stop organized crime. But now, politically active prosecutors have started filing charges against churches, Christians, and pro-life groups, saying that they're organized crime for protesting abortion. Basically, a liberal prosecutor on the federal government level can say a woman has a constitutional right to abortion. If you protest against that, then you are trying to deny her constitutional rights. And they can say that pro-life groups, Christian groups, are organized crime. So it's dangerous when people have the power to define the thoughts or actions of their political opponents as criminal. And the last of the three inchoate crimes is solicitation, trying to get someone else to commit a crime. Here's an example of a criminal justice student at Purdue University who was convicted of ordering a hit on her ex-husband so that she could get custody of the child. If you try to get someone else to commit a crime for you, that's criminal solicitation. What is the actus reus? Urging another person to commit a crime. Well, urging them, what does that mean? What words qualify? Words that simply wish the crime would be done are not enough. Man, I wish someone would kill the senator. I wish someone would kill the president. Well, that's wishful thinking. That's not actually a solicitation to commit a crime. Instead, you must involve effort to get another to commit a crime. Specifically saying, will you kill the senator for me, is enough. It's better if you say, will you kill a senator for me, I'll give you $10,000. But simply soliciting someone is enough, as long as it's more than just wishful thinking. It doesn't have to be addressed to one person. In the picture, perhaps one person is asking another person to commit a crime, but you can actually say it to an audience. If you have a group of like-minded individuals and you say, if anybody here will kill the president, I'll give you $10,000, and there's 100 people in the group. Well, if one of them takes you up on that, that's a solicitation. Mens rea with any inchoate crime is intent. You must intend to solicit, and you must intend that a crime be committed. In Texas, solicitation only applies to a felony. You must solicit or attempt to get someone to commit a felony to be guilty of criminal solicitation. There is one exception, and that's what we see in the picture here. Solicitation of prostitution can be a misdemeanor, but still solicitation. So if the man in the car tries to get the woman to sell her body to him, that would be criminal solicitation. If the prostitute solicits and attempts to get the man to pay her money for her body, that also is solicitation. Either one, either the prostitute or the John, can be convicted of solicitation for prostitution. Let's look at a case coming out of New Mexico. Mr. Cotton was charged with having sexual contact with his stepdaughter. That's, of course, illegal, and he was placed in jail. While in jail, he wrote 2 letters to his wife saying, "Man, talk your daughter out of testifying against me. I don't want to go to prison. Tell her not to testify against me." Well, the first letter he wrote was intercepted by prison officials. They have a right to read letters coming in and out of prisons. The second letter was never mailed. They found it in his cell. Well, did he solicit? The wife never received either letter. He was convicted of criminal solicitation of his wife to intimidate a witness. So the stepdaughter is a witness against him. He's trying to get his wife to talk her out of testifying, and he's charged with criminal solicitation of the wife, trying to get the wife to intimidate a witness in a criminal proceeding. The state argued that he had the intent, because remember, every inchoate crime requires intent. He had the intent to solicit, and he had that was his mens rea. He also had an actus reus. He mailed the letter, or attempted to mail a letter, therefore it's solicitation. Mens rea and actus reus. The Model Penal Code said, the New Mexico Court of Appeals, the Model Penal Code says an uncommunicated solicitation is sufficient. As long as he wrote the solicitation and he attempted to mail it, even though it's not communicated to the wife, because that's who he's attempting to get to commit the crime, even though it wasn't communicated, the Model Penal Code says it's enough. However, the New Mexico court says, when the New Mexico legislature wrote the New Mexico Penal Code, they could have followed the Model Penal Code, but they left that phrase out. They left out the part where an uncommunicated solicitation is sufficient. Therefore, Mr. Cotton's conviction was reversed because the New Mexico legislature specifically left it out, intending that if the solicitation is never communicated, then it's not a criminal solicitation. So she never got the letter, therefore he's not guilty of soliciting her, according to New Mexico law. And of course, each state is different. In Texas, an uncommunicated solicitation is sufficient. So if the same event would have happened in the Texas prison system, where someone in the Texas prison for sexually abusing their stepdaughter writes a letter to his wife saying, "Hey, don't let her testify against me," even though the prison officials intercept it and the wife never gets the letter, he's still guilty of solicitation of his wife to intimidate a witness. And that's the end of Chapter 8C, and actually the end of Chapter 8 altogether. Thanks for joining us, and have a great day.